have some prepared remarks, but I wanted to preface it by mentioning that, and this dovetails obviously with all the other presentations in this section, but my understanding is that there are 5 different groups out there right now considering ways to amend Section 101 or amend the patent statute to address Alice in particular and some of the other recent Supreme Court cases. And I'll also preface my remarks by saying these represent my views, not any group I may or may not be affiliated with. So it's my view that patent law, and in particular the law governing patent eligibility, is in a state of crisis. And what started as a crisis in the confidence in the patent system has now transformed into a crisis of confusion in the patent system. And the crisis of confidence resulted from the application of broad patentability standards that allowed for the issuance and enforcement of numerous patents seen by critics as undeserving of validity under the law. And the crisis of confusion, in turn, has resulted from one of the many steps being taken to address the crisis of confidence. And of course, in particular, I'm thinking of Alice and in particular Alice with respect to narrowing patent eligibility. And so I don't think anybody can reasonably deny that the decisions have had a significant impact on the patent system. And some have suggested, of course, that this impact is positive, that the decisions will increase the quality of patents and patent applications and issued patents, and reduce abusive litigation. And to the extent those positive results exist, however, I think they come with profound confusion, right? I think there's a crisis of confusion. And I think there's 2 aspects to this confusion. Confusion exists first because the current approach to determining eligibility subsumes and confuses to a large extent the relevant policy considerations underlying the discrete patent law doctrines in the patent statute. And indeed, the test for eligibility, while derived from its interpretation of Section 101, as of course including several implicit exceptions, is based on several policy concerns already, and I would say better addressed under the other statutory patent law doctrines, right? And I know this has been discussed, and I'm not saying that those doctrines perfectly address all those concerns, but there is so much overlap, I think there's large room for confusion here. And of course I'm talking about non-obviousness, the written description, enablement requirements, definiteness requirement, and limitation on functional claiming in terms of 112F. But moreover, the concern with preemption of the basic building blocks of human ingenuity, right? This concern that's primarily focused on in Alice, I think to some extent just disregards limitations that exist in the patent statute, and again, some of those same that I've already mentioned, enablement requirement, for example, as well as the limited terms of patents and the existing statutory and very narrow common law experimental use exception, in any way could be addressed by modifying those doctrines to the extent that they do not perfectly address the concerns that exist and that were considered by the Supreme Court, for example, in Alice. But that's the first realm of confusion. I think confusion also exists because beyond confusing relevant policies and doctrines, the current approach lacks administrability. It's exceedingly difficult to understand whether a patent examiner or a court should find subject matter eligible for patenting, given the overarching test that we have. And of course, you know the 2-part test, so I won't repeat that here. But I think this, in particular, the question of whether there's an abstract idea. What is abstract? No one really seems to know. We just look at past cases and try to draw analogies. And then in particular, the search for an inventive concept. So what I would say is, and I'm going to borrow from some Supreme Court justices with respect to other doctrines, I think that the 2-part test is, and this is to borrow Justice Scalia's language, is gobbledygook, right? Another way of describing it is to use Justice Stewart when he was describing hardcore pornography and thus obscenity as, I know it when I see it. And in short, I think the Supreme Court's test for eligibility provides no objective guidelines to guide the analysis. And in particular, with respect to the question of whether there is an abstract idea or an inventive concept. What's ironic, of course, about the situation is despite the confusion with respect to policies and the confusing test, the result of all this confusion is, and I'll say seemingly clear, right? When challenged patent applications and issued patents probably don't satisfy the requirement of eligibility, whatever the test actually requires. And in particular, given the unfettered access to the smorgasbord of supporting policies, supporting different limitations on eligibility, as well as the test's subjective nature, in particular with respect to whether there's an inventive concept present. So at least this is the perception, right? It's not the reality, and we're not quite to the point where we would say, like Justice Jackson did with respect to the invention requirement, which, by the way, the Supreme Court is effectively resurrected with respect to inventive concept, that the only patent that's valid is one in which the Supreme Court's not been able to get its hands on. We're not quite there yet. After all, the Supreme Court, most recently in its 4 cases, at least in one of the cases, split the baby and found at least some of the claims eligible. So not every claim is ineligible. But as was mentioned earlier, the Federal Circuit's application in the first year after Alice has been more stark. I actually count 16 of 17 cases. Maybe I'm counting some of the non-precedential cases, I'm not sure. But 16 of 17 cases, the DDR case, of course, being the lone exception, finding claims eligible. And so the prevailing, if the prevailing perception is that because of the eligibility requirement, patents won't be available to protect inventions, at least it's theoretically possible companies may not be investing efficiently in research and development. Some might say, in fact, they are investing efficiently in research and development because those patents aren't out there to bite them in the end. But at least that question deserves some consideration, and in particular some empirical research, I think. But anyways, given the confusion at least, and at least the risk of underinvestment in research and development, I think it's time for Congress to seriously consider amending the patent statute to find an administrable test. And so I think a revisions, at least a consideration of revising the statutory test is urgently needed. I think in particular we need clarity, and we can have a discussion over what exactly the scope of eligibility should be, but at a minimum the test should be clear and the appropriate policies should be considered separately with respect to the existing patentability requirements, and if we maintain an eligibility requirement, which I'll show later is at least one approach you could adopt here, we should at least have that conversation and have a clear test. So in this piece, what I'm seeking to do is to explain why there's a need to consider congressional intervention, and then I want to think about if these 5 groups out there are to proceed, and if there's money that goes behind some of these efforts, what should be guiding Congress, at least in the sense of how can we maintain improvements in patent quality and maintain reduction in abusive patent litigation, but to focus on appropriate policies, like I said, provide an administrable test, not just with respect to eligibility, but the other patentability requirements, and thus ensure the incentive to invent. So as a starting point, I identify some overarching principles that I think should guide the effort. As I mentioned, shouldn't be surprising at this point, clarity is one thing I think that we should be striving towards if you're going to look at a statutory amendment. I say broad eligibility, right? I don't mean everything is eligible, and we can discuss and have a debate over exactly what the extent of eligibility should be. But at a minimum, broad eligibility, we really are here focused on exceptions to eligibility, not eligibility itself in the main. In terms of, maybe this goes with clarity, but I like this idea of trying to include in the statute some objective guidelines for the analysis, so it's not just a subjective gut feeling that a patent examiner or a judge would have that would resolve the question of eligibility. And then I actually add to that constraint on judicial intervention. I say that because I think the current crisis of confusion is what I call it, that we're in, has parallels to the 1952 Patent Act and the attempt there to rein in the doctrine of invention with respect to the statute to codify a test that includes some guiding principles. And in that regard, I was reading Principles of Patentability, which was an article written by Judge Rich, indicating that yes, non-obviousness is a subjective analysis, but at least there are some objective guidelines in the test that can provide some constraints that help. So in the end, I am considering and analyzing 3 paths forward, and I'll present them up on the screen in just a moment. But the first is what I call the laundry list approach, which would involve creating a clear, hopefully, clear and exclusive list of specifically identified ineligible subject matter. And I'm going to just preface these, then I'll put them up on the screen. The second is different. It would involve the codification of an exclusive standard for examiners and judges to apply to determine eligibility. And one, and there's really 2 subsets to this approach. One would be something similar to the anything under the sun made by man articulation of eligibility, maybe with an added component for mental steps. And then another approach under this idea of a standard being put into the statute would be focused on practical applications or embodiments. And I'm not saying this is novel, right? I'm drawing from a whole bunch of literature in this regard, even though I'm not mentioning it now. But this idea of focusing on whether there's a practical application or embodiment of a otherwise ineligible subject matter. So that's the second approach is a standard written into the statute that we can hopefully apply with some guidelines. The third is an approach that's more radical, admittedly, but it's an approach that would eliminate the eligibility requirement, and you may say that's crazy, but the idea then would be to focus on amending the other patentability standards to incorporate and to address any policy concerns that are not otherwise addressed by those sections. So now I'm going to pull up my the language I'm looking at with the specific examples, but I should preface that the introduction of these proposals, they serve merely for my purposes as examples of proposals for discussion and analysis and approaches to amend the patent statute. And like I said earlier, substantively there need to be careful consideration of each proposal. I'm not putting forward as this is the proposal we need to adopt, but I think it's helpful to look at some language to identify what is helpful, what is not helpful, and to identify concerns that they do address and concerns that they don't address, or new problems that they introduce. So here's one approach. This is proposal A. I'm calling it the laundry list approach. So if you look at it, it would include in subsection A the broad statement of eligibility. It would recite that a patent shall be granted for any claimed subject matter that's useful and meets the conditions and requirements of, and now specifically identifying sections 102, 103, and 112. By the way, you're probably wondering what's the deal with the color. The color I want to focus on that language in particular, and so we'll do that. So the new language would provide a basic rule, right? Any claimed subject matter is entitled to a patent so long as it's useful and meets the conditions and requirements stated elsewhere in the patent statute. And now we're specifically identifying where those exist, 102, 103, and 112. So compared to the current text, the language would eliminate new and useful in favor of only useful, right? And the idea there is to say, well, new is really a concern of section 102. It would also avoid the use of the term inventor if the concern is with the inventive concept or the requirement of invention. Get away from use of the term inventor. And so I think both of those changes would seek to eliminate the search for an inventive concept and confusion between the 101 analysis and the other analysis, for example, under 102, 103. You'll notice that the language would eliminate traditional subject matter categories. And the idea here, I think, would be to eliminate these categories, to eliminate the vehicle for the Supreme Court to continue to apply its created exceptions to the statute. Subsection B is really where I call it the laundry list approach, because here is where there would have to be a negotiation over exactly what is ineligible, and let's put it in the statute. I do want to highlight for anybody who studied the Ipsc, this is borrowed from the Ipsc, Article 52. What's not borrowed is any technological arts test, so it's dispensing with that. And the idea would not really be here to harmonize, although that would be, I guess, an approach here too. The idea I see is we should codify, starting with, and I'm starting with the Ipsc language, but the idea would be to codify exceptions to eligibility based on what is best, and not just copying what they did in Europe. And so what I think is interesting about the European approach in particular is that they have identified what's ineligible, but then they have subsection B2, which seeks to limit the scope of those exceptions. And sorry if I'm standing in front. The exceptions are intended to be limited when they are claimed as such. In other words, if you have to have a claim that is claiming that ineligible subject matter. If it goes beyond, if it claims something different than that ineligible subject matter, it's not ineligible. And this exception is the laundry list approach. In the AIA, there was an exclusion of subject matter, and so subsection B3 would actually just repeat the language from the AIA section 33 that excludes particular subject matter. And then there's hopefully some clear language in B4 that says these are the exclusive exceptions. All right, so that's the laundry list approach, right? It requires identifying specific ineligible subject matter, hopefully using clear language, and then some restriction on courts' application of those exceptions by limiting when they're claimed, limiting the exceptions to when they're claimed as such. Okay, so proposal B, right, there's actually two proposals. The first one is this idea, if we were to try to codify the idea by P.J. Federico in the 1952 House and Senate report that what is eligible is anything under the sun made by man, we could eliminate some of the gender-specific language, perhaps, and go something that's, as expressed here, not the result of human effort. And then added into this is this idea that, well, is human thought human effort? Sort of, but that's not really what is intended here. So a clause added to that would be this idea that you cannot obtain a patent that can be accomplished, or a claim that can be accomplished only using human thought. All right, so I know another idea here under this idea of putting in a standard into the statute is what I'm calling here Proposal B2, and it's a focus on whether they're embodiments or applications of otherwise ineligible subject matter. Right? So you'll see, as I'm going to focus on the red language, the idea here would be to leave the original text of Section 101 unchanged, but then to focus in a new Section B on a limitation on what is ineligible. And so the idea is where it starts, unless a person having ordinary skill in the art, and by the way, this is where I would try to work in some objective guidelines into the analysis. And I know there was discussion earlier, I think it was in the last section, this language in enablement doesn't really mean anything. Nobody actually does that. Well, with respect to 103, it's a significant part of the test, and I'm not convinced it's irrelevant part of the test under Section 103, but you can introduce some objective guidelines. In other words, it's not just up to the unfettered subjective decision of the judge or the patent examiner. They have to address this question from a perspective, and that's of one of skill in the art. But the question really gets to whether the claimed invention as a whole is directed to any embodiment or an application of an otherwise ineligible subject matter. You'll notice the last, I think it's the last sentence, eligibility for patenting under subsection A shall not be negated by how conventional or routine the embodiment or application is, or the lack of inventiveness. So this is hopefully some pretty clear language that says, look, inventiveness is a question for 103. It's not a question with respect to eligibility. And in that regard, it's actually similar to the last sentence in section 103. Okay, so as I mentioned, Proposal C is, and I'm calling it here, laying the ghost of the eligibility requirement, which is a purposeful reference to Judge Rich's idea in Section 103 that he was going to lay the ghost of the invention requirement. But it's the idea that Section 101 should be stripped of any substance in terms of an eligibility requirement, but the policy concerns, to the extent we still have them, should be addressed in the other sections of the patent statute. So this language here, I think, is one way to change 101 so that it doesn't include any restriction. It's a right to a patent section at this point. From there, then the question is, well, if you're going to amend the other statutory sections, what do you do with those sections? 112, in particular here, if you're going to delete any substance of any requirement in Section 101, I think you need to preserve the utility requirement. And if you look at, you study the utility cases, there's the argument in a lot of the cases that 112 already has the utility requirements, that the idea that the enablement requirement subsumes the utility requirement. You have to disclose in the specification the utility. And so this amendment would actually just be a codification of that doctrine in that case law. This is really where the rubber meets the road with respect to amending the other statutory sections. There's lots of ideas here. I'm running out of time, so I'll just say that, look, you could try to amend 112 to address concerns with abstract claims, which is what here is 112G1. And then with respect to natural laws and natural phenomena, you could amend Section 112 also to address that. I want to point out, though, with respect to this 112G2, it's actually interesting because what it would do is require claims to be construed not to cover natural laws. So it's an interesting approach that is a matter of construction of claims, which I think is a different way of thinking about the problem. And then if you're going to amend the other statutory sections, maybe this is an opportunity to codify an expanded experimental use exception that's directed to experimentation with inventions. And this is some proposed language there. So I'm interested in reactions.
Just 3 quick things. For purposes of clarity, you should probably get rid of the word invention because it imports historic baggage and the same types of conceptual questions that are still present. Second, when you import the European approach of as such, it hasn't been entirely successful to try to figure it out. It raises 2 important corollaries. The first is they just shifted the same difficulties of line drawing to inventive step. I'm not sure they're any happier with it. And the more important point is what policy is 101 therefore trying to achieve. And at least in their context, what they're saying is that the inventive step has to be a technical at the point of novelty. So if 101, as I've suggested, actually should treat the discovery as priority against the applicant, all the things you're suggesting won't get at the proper policy, but you can't really do this until you get agreement on what the policy is. So.
Right. No, I admit that. I'm just, given that they're doing this analysis right now, I want to at least consider some examples. And what I'll be doing in the paper is trying to poke holes in these and poking holes in the language to see if any of them are better or any of them even reasonably come close to what would be acceptable. Sure, Mark.
In the sort of first proposal, I notice you do away with the statutory subject matter categories. I wonder how important that is to your view, because it seems to me that they do at least some work that is not captured by your exception. So the one case you might look at in that respect is in Renoyton, right? The propagated signal claim.
Right.
Is it the case that everybody who owns a telecommunication wire is directly infringing every computer program sent over that wire?
Right.
Court says no because it's a propagated signal is none of these things, but I'm not sure if it's in any of your exceptions.
Yeah, exactly. Yeah, and I recognize that. I think some proposals that we're going to see are going to try to do away with those traditional subject matter categories, and we need to be perhaps concerned about that. What is the intended result there? But you'll notice in other proposals the language was still there. I think they definitely do work, that language, and so we shouldn't lose sight of that. I'm over time, so I'm still interested in your comments and questions, so I'll be up afterwards. Thanks.